Mr. Deputy Chairman, this small measure, which I thought would not take much time, has been debated upon with a certain amount of interest and enthusiasm. Criticism has been twofold. One set of honorable members who have participated in the debate have put forward the thesis that this is much too drastic a measure and that it cuts at the root of the rights of the landlords in regard to the eviction of tenants which they have been enjoying under the provisions of Section 13 of the Rent Control Act. Very lengthy and elaborate arguments were advanced, some of them legalistic, and a case has been sought to be built on the ground that great hardship is likely to accrue to the landlords if this temporary relief is granted as contemplated by the amending bill. Then, sir, there has been another set of speakers, some belonging to the benches opposite and some of this side of the house, who have supported the measure so far as it goes but have further taken the line that it does not go far enough and that it should be made even more stringent. If I may respectfully say, that is some justification for the present measure in the form in which it has been brought forward. These violent reactions, one way or the other, do indicate that there can be a violent difference of opinion and difference in approach when dealing with a problem of this nature, and from the very nature of circumstances, a certain amount of balanced approach has to be brought about so that the hardship to which the tenants may be exposed may be minimized, and at the same time the genuinely difficult cases of landlords may not be covered by this temporary protection. An effort has been made to strike a mean of that nature when this bill was drafted and brought forward before this honorable house. The argument that has been put forward by the set of honorable members, whom I may describe as pro-landlord group, has been that under Section 13 of the Parent Act, after obtaining the decree, the landlord will not be entitled to execute it, or if he brings forward a suit he will not succeed, and that would lead to a great deal of hardship to the landlord. All types of arguments have been advanced in support of that view. Various clauses have been examined at considerable length by two very experienced parliamentarians. They have posed a question and asked for jurisdiction of this temporary relief with regard to the cases which are covered by those clauses. The basic fact which is to be remembered while examining a provision of this nature is the practical human side along with the purely legal side. After all, it is not the government's case at the moment that a case has come for doing away with the various changes. A case, however, does exist for affording some relief, but what from that relief should take is a much bigger issue which was intended to be thrashed out after a careful inquiry and investigation of all the relevant facts. I said at the outset that it was the government's intention to go into the question carefully, and the intention is to appoint a committee upon which the various interests may be represented, and in that we also hope to be benefited by the advice of honorable members of parliament, and it will be for that committee to examine the various aspects and suggest as to what revision this way or that way towards the right or towards the left is called for, and pending that investigation there should be some relief to the people who are on the point of being thrown on the roadside. It could have been argued that the relief should have been suggested by some of the honorable members, that this temporary relief could cover all the clauses. Well, there may be some force in that, but it is a question of balancing the inconvenience caused to one group as compared to the other, and in the judgment of government it was considered that if this selection is made and those cases are only brought within the purview of the present amending bill, whereby the landlord is not put to any real hardship, then it will be a case really for giving relief to the tenant. Now, if these clauses are examined, they will be grouped broadly under one or two categories. The position in Delhi as it obtains today is that the price of land has increased considerably. My honorable friend who sits on semi-opposition benches made out a case of imaginary hardship for the residents of Delhi. He said lakhs and lakhs of refugees have come down here and they have caused a lot of inconvenience and hardship to the old residents of Delhi. Well, some hardship may have been caused, but he conveniently forgets that it is the resident of Delhi who is the owner of small buildings. Sir, agriculture is an important subject because 75% of the population of this country is rural and dependent on agriculture. I shall briefly touch upon the achievements in the agricultural sector in the past 44 years. This can be gauged from the fact that both India and China have the same area of cultivable land, which comes to about 14 crore hectares. I would like to draw the attention of the Honorable Minister towards the fact that China is producing 45 crore tons of food grains, while India's production has been between 18 and 19 crores tons in the last 3 or 4 years. This means there are certain reasons as a result of which our production is low. Sir, I would like to inform the House that agriculture contributes 33%, industries 29%, and other services 38% to the national income. The contribution of agriculture can be easily raised to 50% in the national income. The main reasons for low national income are the wrong policies and their faulty implementation by the government. To increase the national income, we must raise the contribution of agriculture to 50%. Sir, I would like the Agriculture Ministry to note that irrigation and fertilizers play a key role in increasing agricultural production. Sir, so far as irrigation projects are concerned, out of all the projects planned in the post-independence period, about 200 big and medium projects were undertaken. At the end of these 44 years, only 65 projects have been completed and 2300 big dams have been constructed and 1800 dams are yet to be constructed. But even in this age of science and technology, 70% of the water of these dams gets evaporated. Sir, fortunately our country has been blessed with great natural wealth. Underground water is also available in abundance and can be utilized best to encourage irrigation through tube wells in North India. The maximum credit of the achievement made in this regard so far goes to the farmers. Electricity is the basic necessity to meet irrigation requirements. I need not say much about the state of electricity throughout the country, particularly in Uttar Pradesh, which is the most backward state in the country. Therefore, my submission is that unless we increase the power generation, we cannot solve the problems baffling us. Mr. Chairman, sir, through you, I would like to submit to the Honorable Minister of Agriculture that it is a matter of disadvantage for us to continue the projects in hand for a longer period because the expenditure goes on increasing every year. The result is that the expenditure increases twice as compared to the initial cost. It creates a number of difficulties and the work of the projects comes to a standstill for a long period. In Uttar Pradesh, several projects have been lying incomplete due to the non-cooperation of the central government. In this connection, I would like to urge the Honorable Minister of Agriculture that the central government should provide funds for these projects in time so that the projects are completed and the farmers get irrigation facilities and also the production of food grains in the country may increase. Mr. Chairman, sir, I would also like to submit that according to our experts, at least 33% of the total land should be covered by forests. But due to the continuous denudation during the last 44 years, presently only 6% of the total area is covered by forests.